sticks, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government love the government.
Welcome to The Politics Guys, presents the U.S. Constitution. The Main Politics Guys is a place for bipartisan, rational, and civil debate on American politics and policy. What we're now also bringing you are in-depth series on topics in American politics and policies. Our Politics Guys Presents series will dive deeply, 1 week at a time, into a particular element of U.S. politics. In the Politics Guys Presents the U.S. Constitution, I, Dr. Trey Orndorff, and my co-host, Dr. Ken Katkin, will be diving into the U.S. Constitution, article by article, clause by clause. This multi-year project was originally only for supporters, but is now generally available to you, the listening public. If you like these shows, remember that the Politics Guys are presenting other topics right now to supporters. So head down to the show notes to get access to all of the Politics Guys and now all of the Politics Guys Presents series. In the meantime, I hope you enjoy yourself as you join me and Ken Katkin on our journey through the U.S. Constitution. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I am joined again for this midweek supporters exclusive show with you, Ken. Ken, how are things going?
Oh, it's so great to be back, Trey. It's great to have you back.
Yeah, it is. Well, and I'll tell you, one of the biggest disappointments that I kind of faced was we had just started doing what I thought was this really good idea from one of our executive producers, which was, why don't you guys, originally the thought was we're just going to read through the Constitution. But that didn't seem like enough to me, right? And so as we talked about it more in our groups, we thought, hey, why don't we actually kind of analyze the Constitution as we go along? And since obviously you're a law scholar and I'm adjacent to law, as a matter of fact, I do teach a con law class at the undergraduate level. You know, we thought, okay, this would be the way to go through. So, of course, then, Mike gets to have all the fun last time. And I don't get to be a part of that. So I think what we're going to do, Ken, is we're going to kind of approach this in the way that you've even said that you've approached it with your students, although maybe not your first way of doing it, is we're going to kind of zip a little bit forward. We've been working in Article 1, but we're going to kind of start with the end of Article 1 first, which is at the end of Article 1, Section 8, which is the necessary and proper clause, so that we can then come back and either in this episode or probably even more likely in future episodes, get through some of those really important powers. So, for example, credit, you guys have already talked about commerce, but we'll get to those. But Ken, this last phrase in Article 1, Section 8, we're kind of going to do what we've done in the past, which is just kind of read this and then have some conversations about it. But it says this, and it's a really, really important one. It says, quote, "to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof," end quote. And what really makes this a big deal is in part there's four major kinds of powers that come out of the Constitution, but the two major ones that come out of Article 1, Section 8, kind of broadly constituted, are you have your enumerated powers, or that list of powers, for example, to regulate commerce with foreign nations, as Ken, you and Mike were talking about last time. But then you have what we have as being not enumerated powers. You have the implied powers, which come from the necessary and proper clause. And this is actually a huge amount of debate about this early in constitutional history. This is the first constitutional issue in many ways, and it is definitely happening while the ink is still wet on the paper, because you kind of have two groups. On the one hand, you have Thomas Jefferson and others who want a real strict construction of what the necessary and proper clause is going to be. And then you have another group who kind of center around Alexander Hamilton, who we sometimes think of as being a broad construction, who wanted to be able to read a lot of potential powers in here. As a matter of fact, one of the earliest of these, as I was hinting, is this question of the national bank, which kind of corresponds with a number of those enumerated powers, and eventually culminates in McCulloch v. Maryland. So Ken, what are the important elements of the necessary and proper clause?
Yeah, well, it's a bit of a sphinx. It's a bit of a mystery because the structure, the basic structure of the framers' design for Congress was that you use the phrase enumerated powers, and that's exactly it. They made a list of powers that Congress has, and the idea was that this would be a limited government because we already had state governments. So state governments are governments of general jurisdiction. They can basically legislate on any subject. And the idea was that if we're overlaying a United States government on top of that, the United States government would only be able to legislate on certain subjects, and on subjects where there was concurrent jurisdiction, things that the United States government could legislate on, and states also could legislate on. Then under the supremacy clause, federal law would be supreme, federal law would trump. But correspondingly, there'd be a lot of areas that state laws could legislate on that didn't fall within Congress's enumerated powers. And so states would therefore be supreme in those areas because they would be the only competent legislature in those areas. So the big structure here is that there's only certain things that Congress is allowed to legislate about, and those things are listed on a list. And so most of Article 1, Section 8 is the list. It just gives us the list of things that Congress can do. It can regulate interstate commerce. It can make intellectual property law. It can make immigration law. It can make bankruptcy law. It can make an army. And there's this long list there. But then when we get to the end of the list, again, where the structure is supposed to be, these are the things that Congress can do, and it can't do anything else unless it's on the list. Well, the last thing on the list is that Congress can make all laws which are necessary and proper for carrying into execution all the other laws. And in fact, not only just all the other laws, but Congress can even make all laws which are necessary and proper for carrying into execution other powers that are vested in the other departments, in the executive branch and the judicial branch, not just the powers that are vested in the Congress. And so it's sort of, in a way, it threatens to undermine the whole structure, right? You have a structure where you say Congress can only pass laws about things that are on the list. Here's the list. The list is a lot of, some of them are pretty big things like regulating commerce, but, ultimately it's a list that, is finite. But then when you get to the end of the list, and everything else that's necessary and proper. And so,
Well, and
so
that's a great question because, one of the big areas we've talked about this in earlier shows, right? This was one of the areas where you have issues with what the Federalists end up calling the Anti-Federalists. They thought that this would get used too extensively. And so, as a matter of fact, two of our amendments are purportedly to kind of maybe put some guardrails around the Sphinx. I don't know,
Yeah.
in the Ninth and 10th Amendment, although it doesn't end up working out quite that way. That's one of the questions there, right?
Right. I mean, in fact, the whole Bill of Rights, in a way, not just the Ninth and 10th, because Madison was of the view that it was a bad idea to have a Bill of Rights because Madison said, look, the way I've structured the Article 1, Section 8, there's only certain things that Congress can do. And it can't do the things that aren't on the list. So, for instance, Congress can't abridge freedom of speech or free exercise of religion or anything like that because it doesn't have any enumerated power to regulate speech or to regulate religion. So it already can't do that. And Madison said if we said that there's a list of things that Congress can't do, then people are going to start thinking, well, then Congress can do everything else. And so that would kind of, undermine the idea of limited enumerated powers. So he actually thought, all of that would just create an unfortunate negative implication that Congress could do anything that's not prohibited. But the Anti-Federalists did insist on a Bill of Rights. And as you point out, they especially insisted that it include a Ninth and 10th Amendment. And the Ninth Amendment says that the enumeration in the rest of the Bill of Rights of certain rights shouldn't be taken to deny or disparage other rights that are retained by the people. So they're sort of trying to remind us that we have a lot more rights besides the rights that are listed in the Bill of Rights. But I guess they thought that it wasn't necessary to specify what those other rights were, because I think they thought the idea was, well, everything that Congress doesn't have an enumerated power to regulate are the things that are all of our other rights. Um, but that is kind of, all of that is in great tension with this idea of having a necessary and proper clause. And some of the framers were quite opposed to it. Jefferson really hated it. He called it the sweeping clause, and he thought it basically undid all the work that the structure of limited enumerated powers did. But the first really great interpretation of it from the court doesn't come until, as you said, the case of McCulloch versus Maryland around 1819, and it's an early and still highly influential case about how to interpret the meaning of the necessary and proper clause.
Yeah,
And in fact,
and not a little bit high. I mean, it has been cited over 6,000 times.
Yeah.
As a matter of fact. Now, but before we move forward, because we need to get in and chat about McCulloch. Okay, so Ken, what you were saying about the case was, it comes all the way back really to understanding implied powers to McCulloch v. Maryland, right? A case that deals, well, not just with the powers of the federal government vis-a-vis a bank, but also the ability of states to potentially impact the execution of Congress's power, in this case, through taxes. So take us through McCulloch a little bit there.
Sure. And I like the clever marketing ploy there of like teasing that they'd have to pay to hear me talk about McCulloch. So now
Well, listen, you're incredible at what you do. There's no question about that, and I'm adequate. So I mean, the only
so the McCulloch, I think the important part, if we're talking about the necessary and proper clause, is really the first of the two questions you asked, which is it even constitutional for Congress to create a Bank of the United States? And the Bank of the United States that Congress had enacted in the 1810s, it was a different kind of thing than what we think of today. It had some attributes of what today's Federal Reserve Bank, but it also had ordinary retail banking operations. So you could actually just have a checking account at the Bank of the United States, which is something you can't really do at the Federal Reserve today. But yet it was doing all the central banking functions at the time, and it was our first central bank. And so when Congress created one, the controversy does reach the Supreme Court because Maryland, the state of Maryland, lays a tax on the bank's commercial operations.
I.e. the part that is customer facing, you might say.
Customer facing, yeah. That the Bank of the United States actually had retail banking branches in Maryland, and so people in Baltimore would do their banking there. But it was an instrumentality of the United States government. And when Maryland starts trying to levy taxes on the bank's commercial banking operations, the bank never pays it, and that leads to a lawsuit that ultimately reaches the U.S. Supreme Court. And at the time, probably the more important question was whether Maryland could tax the bank. But for posterity, the far more important question was whether there can even be such a bank. Because in the litigation, for various reasons, the argument comes up that Congress doesn't even have the power to have a Bank of the United States, and that it's unconstitutional to have a Bank of the United States. And the argument that's made in support of that assertion is that we have a government of limited enumerated powers. There's a list in Article 1, Section 8 of all the powers that Congress has. That list doesn't include powers to operate a bank or to operate any kind of financial institution or even any kind of commercial businesses. There is a power to have a U.S. Treasury, but not to have an actual bank. And so the government has to respond to that argument and try to explain why it is constitutional to have a bank if Congress can only do things that it has an enumerated power to do, and it doesn't obviously have any enumerated power to have a bank. Now, sort of the first cut that Congress argues is, well, we can do some other things too because we have implied powers, not just express powers, and the implied powers that we have are recognized in the necessary and proper clause. That sort of tells us that there's additional implied powers. Well, that sort of forces the court to have to grapple with the question: are there implied powers? And if there are, how do we know what they are? Because they're not expressed; they're only implied. And so on the question of are there implied powers, and this is one of the great opinions by Chief Justice John Marshall, he says absolutely there have to be. There are and there must be. And his arguments for why there are implied powers, he says, first of all, the purpose of the Constitution is to create a government that's actually capable of achieving certain objectives for the people. And we did have a experience before we ratified this Constitution with weaker forms of government under the Articles of Confederation and under the Articles of Association that preceded the Articles of Confederation. And those governments were so weak that they couldn't achieve the purposes for which they were instituted. And those purposes include things like being able to provide for the common defense, or being able to establish an internal free trade zone within the United States, or make certain kinds of internal improvements. And the framers went back and did this Constitution to ensure that our Constitution could create a government that could do the things it needs to do, could survive, could endure, and would be around for the long run. That's one of Marshall's premises. His other premise is that that the Constitution has to be a people's document. It was submitted to the people for ratification. It has to be something that ordinary people can actually read, can maybe keep copies of in their shirt pockets, can sort of understand that it's not a lawyer's document. It can't go into the level of detail that a legal code would. If it would be, paid, volumes and volumes of hardcover bound volumes like the U.S. Code is, and then it would be a lawyer's document, not a people's document, but it's meant to be read. And so Marshall says, so we've got a document that's meant to be read and understand by ordinary people, and therefore has to paint in very broad strokes. It can't be super detailed. And we've got a government that's supposed to be able to achieve its essential ends and not supposed to fail, and the country's not supposed to fail. And from those two premises, he says the Constitution necessarily has to give the government the implied powers that it needs to be able to do the things that it needs to do. And it has to be not penalized for the fact that not everything is spelled out right in this written document. So that's sort of how he sort of establishes implied powers. And in fact, he says because of those arguments, that there would be implied powers even if there was no necessary and proper clause, that they must be there. But then he says the necessary and proper clause is the text in the Constitution that reflects that. So it's not that clause creates the implied powers. It's that clause acknowledges the implied powers, which, because of his other arguments, must necessarily be there. And then he has to address the question, well, if there are implied powers and they're not expressed, then how do we know what they are? And doesn't that completely unwind the whole system of limited enumerated powers? Because if we say Congress can do A, B, C, D, E, and F plus everything else, then we really have an unlimited government. And
what was the point? What was the point of the foregoing powers?
Yeah. But Marshall's answer to that is, he says, no, they can't do anything else. The only thing that they can do under the necessary and proper clause and under the implied powers is they can pass laws that provide useful and convenient means of giving effect to the other enumerated powers, so that they can come up with ways that they think would be effective ways of carrying out their other enumerated powers. And they get a little bit of deference in terms of their judgment about what would be effective. So the court's not going to micromanage those choices, but the court is going to be watching for pretext. And if something really seems unrelated to carrying out any of the other enumerated powers, then that's not going to be a permissible use of the necessary and proper clause. But in the example that's before the court, the example of the bank, the court says, well, of course, Congress doesn't have to create its own bank, but Congress does have to do certain functions that are in its enumerated powers. It has to lay and levy and collect taxes. It has to spend. It has to borrow. It has to raise and support armies, which might be spread out all over the place, which means there's going to have to be money all over the place. And it probably would be able to do all those things just by collecting taxes and putting them in the ordinary commercial banks wherever they are until they can transfer it back to the Treasury or something. It's not absolutely necessary that Congress operate its own bank. But operating its own bank is a useful and convenient means of carrying out all those other functions, because if it collects taxes from people all over the place and there's branches of the Bank of the United States all over the place, then it's useful and convenient to go deposit those revenues in those banks. And if the Treasury needs a loan because there's going to be some deficit spending, it's actually useful and convenient to be able to borrow from a federally owned bank rather than having to pay out all that interest to other private interests. And if we're going to raise and support armies and they're going to be in faraway places, it's actually useful and convenient to have a bank that we can trust, will be secure and not have to rely on whatever frontier banking system there is out there that might get robbed or go belly up. And so the court says, so to give effect to all those other powers, which are Congress's enumerated powers, Congress could find that operating a federal bank is a useful and convenient means of doing that, and that's the relevant test under the necessary and proper clause. So that's really where we get the modern doctrine of implied powers and a test for how we decide what powers are implied.
And the opposition to that, I think, is useful to understand too, Ken, right? So, and you summed it up so beautifully there about, Marshall's opinion is, well, the necessary and properly effectively means kind of efficient. And Jefferson, as you noted, who was against that, he took direct eyeball beam at that and went, no, that's not what those words mean at absolute all, right? As a matter of fact, we get that coming together in the over the debate in Washington's cabinet about this question as well. But the next big takeaway, which I think is is worth thinking about historically, right? So Madison, one of the guys who is a part of the Constitutional Convention, he's actually part of the response against it. And again, I think it comes back to the nature of the necessary and proper clause that's so confounding, right? Madison, he leads the opposition in the House as it being unconstitutional because, as in his words, he says, quote, the essential character of the government would be destroyed, end quote, if we took Hamilton's view. And he actually is the guy who is often attributed to having an understanding of Supreme Court cases and law that we've talked about before, maybe not explicitly, as originalism. And he says, look, there's kind of three principles you've got to look at. Does an interpretation that destroys the very character of government cannot be just? He also says that where the meaning is clear, it has to be accepted regardless of the consequences. And finally, that he uses a different kind of older English word, but where it's hard to understand the case and the meaning of the parties, you have to take a look at the collectible and reasonable evidence, or in this case, he knows his evidence. Now, what's so particularly confounding about this that nobody knew at the time, but we know now, of course, is that in Federalist number 44, which was, we now know, written by Federalists, but wasn't known at the time of this debate of McCulloch, that he had actually endorsed implied powers. In number 44, Madison argues that implied powers are good because it empowers the government, unlike the word used in the article, which was express. And so, even in the early framers, I think it's useful sometimes for listeners to recognize that here is Madison. He is in the constitutional debate. He takes a particular view, and then in the House, he has obviously a slightly different view, which is also a conflicting view with what he writes in Federalist 44. And so one individual can kind of have different interpretations of even that quickly of the necessary and proper clause. And I think sometimes it's useful to get that because I don't know, Ken, I think a lot of my students, at least, they'll think about, there's kind of this there was this uniform framers, the uniform framers, and they thought A. And I'll say, it's a little more complicated than that, right? You've got a number of major groups, and sometimes even the same individual changes and evolves during a relatively short period of time.
Hey, it's Sterling K. Brown from the Hulu original series Paradise. The next chapter begins as Xavier's search for his wife takes him above ground, and what he finds will change everything. It was never just about the bunker. Tune in and discover the truth lies outside. Paradise, the official podcast, premieres February 16th, and stream Paradise on February 23rd on Hulu and Hulu on Disney+.
Yeah, you actually left out the final chapter in Madison's evolution, but after he led the opposition to the bank bill in the House, he later found himself the president of the United States, and
Oh,
he
true.
is the president. Yeah, he's the president who signed into law the bank bill. He signed it into law. So by then he was all the way on the opposite side of where he was
Now,
when he
doesn't he
was
sign
in
in
the
the
House.
second
Yeah.
one? The second
Yeah,
bank in the
yeah,
United
but
States?
that's the one that is the one that's in McCulloch for Maryland. It's the second bank that's in the
Yeah.
McCulloch v.
Oh, that's
Maryland
right. Yeah,
case.
yeah,
Yeah,
yeah.
yeah.
Which is
So yeah,
which is weird
I'm
because
sorry.
then you have Jackson. It's under Jackson's presidency that he kills the second bank in the United States, but tells Madison's. Let's see, is it Madison's son that he's working with at that? Now I'm getting my history off here, Ken.
Well, yeah, Jackson actually didn't re-up it. So the second bank, the same bank that Madison signed into law and defended in the McCulloch case successfully, that had a 10-year sunset in the law. So after 10 years, Congress passed a reauthorization bill to keep it open, and Andrew Jackson vetoed it on the grounds that the bank was unconstitutional. But this was after the McCulloch court had already said that it was constitutional. So then they closed down the second bank. But the one part I wanted to tell when you talked about the Madison and especially Jefferson's counter arguments,
hmm
there was a counter argument that I think is worth focusing on about the meanings of the words necessary and proper. And
Yes.
so the opponents of the bank said that the necessary and proper, that those words are limits, that if it's unnecessary to do something, then Congress can't do it. So the idea would be that, well, sure, Congress has to tax and borrow and spend and raise and support armies, but if Congress can do all those things without operating a federal bank, if it could put its money in commercial banks and until it can transfer it to the Treasury and this and that, if Congress could accomplish all of its enumerated ends without operating its own bank, then it's not necessary to operate its own bank, and therefore it's not necessary and proper. So that was the sort of verbal argument, but Marshall did address that in the McCulloch case, and he said it's important when you're thinking about this to note that all of Article 1, Section 8, including the necessary and proper clause, is an additive list of powers. In other words, each power that's listed is just another power. So Congress has the power to regulate commerce, plus Congress has the power to make immigration law, plus Congress has the power to make bankruptcy law, plus Congress has the power to make intellectual. It's all just being added. And so he says, and then if you look at the Article 1, Section 9, which we'll talk about, in a future show, that's all the limitations on what Congress can do. And from that, Marshall reasoned that if we're trying to figure out what's the right way to think about construing the necessary and proper clause, you have to remember that it's in an additive list of powers. It's not in a list of limitations. And so it must be that it adds more power to the other things that Congress can do, and not that it puts any limits on the other things that Congress can do. Because if it was designed to limit to only the things that are necessary, then it would be in Article 1, Section 9. But since it's in Article 1, Section 8, it must be additive. So that's his kind of grammatical response to that argument about necessary and proper.
Yeah, and I think it's hard for us sometimes to understand how powerful that is because, as you and Mike were talking about, in the contemporary Congress, a majority of the powers that Congress gets is actually from that to regulate commerce with foreign nations, and most importantly, that second phrase there, and among the several states. The necessary and proper clause today isn't as often a point of contention, Ken, is it? I mean, I can't even think of a contemporary case where that's up for debate anymore. So, is there a case that I'm missing, or am I
Yeah,
correct in that it's really moved to these other powers in the contemporary period?
yeah, you are correct, although there is a case that you're missing. But the in general, yeah, after McCulloch, I'm sure almost all observers at the time would have thought, boy, Marshall really opened the floodgates here. Now Congress is going to lean very hard on that necessary and proper clause, and it's going to do all kinds of things and claim that these are implied powers. Um, And that mostly didn't happen. And I think what mostly did happen is that the court expanded its interpretation of the power to regulate interstate commerce, and that became much more of a workhorse for Congress. But on the other hand, there are modern cases that rely on the necessary and proper clause. It didn't completely vanish. So one modern case from the 21st century involves there's a federal statute that deals with sex offenders who are in federal prison. And what it says is that if a sex offender in federal prison finishes their prison term and otherwise could go home, but the warden of the prison believes that they're still sexually dangerous predators, and releasing them would threaten the public safety. The warden can call for a mental health hearing and have them, if they're found to be still dangerous, have them bound over to a mental hospital. They'd get out of prison, but they wouldn't be released. They'd go to a mental hospital. So that's all in federal statutory law. And in a case called United States versus Comstock, again, a 21st century case, that structure gets challenged on the grounds that Congress doesn't have any enumerated power to make laws about mental health commitments or about sexually dangerous predators, that just none of that stuff relates to anything in Congress's enumerated powers. And so the government does defend on necessary and proper clause grounds, and they defend it successfully. And it's actually a very interesting opinion because it's a little bit of an attenuated group of steps to even get back all the way back to how this relates to any enumerated powers. And you'll remember that in McCulloch, as we just talked about, the Marshall says, well, Congress has some implied powers, but that's only implied powers to do things that are useful and convenient means of giving effect to its express powers. And so, it's sort of put to the government in this Comstock case, well, how is committing a sexually dangerous predator to a mental health institution, how is that a useful and convenient means of giving effect to any of Congress's enumerated powers? What enumerated power would that even relate to?
And wasn't that effectively the argument of Clarence Thomas and in part Scalia in their dissent in the Comstock case?
Yeah, Comstock, they dissented, and they said this doesn't relate back in any way to any enumerated power, and it is unconstitutional. There were certainly dissenting votes who took that position. And said
It's
that
Roberts and doesn't Roberts and both Alito vote with the majority in that one, so that they saw that connection.
Yeah, I actually can't remember exactly all 9 votes.
I just popped it up. It's Roberts, Stevens, Kennedy, Ginsburg, Breyer, Alito, and Sotomayor. It was going to bother me if I didn't look that up. So there we go. There you go. I'm sorry.
So you looked it up. So I'm sure you're right. Yeah. So the dissenters are saying this, even under the broad standard of McCulloch, there's no connection between, say, locking up sexually dangerous predators in a mental hospital and regulating interstate commerce. It's one's not a useful and convenient means of the other. But what the court says is, well, it is, but it just takes a few steps in the chain of reasoning. So the court says, that violent crimes pose burdens on interstate commerce, and so Congress enacts laws against violent crime because if you didn't have laws against violent crime, then violent crime could have a substantial effect on the national economy. And so once Congress makes certain violent crimes a crime, it becomes necessary to, imprison people who are convicted of those crimes. And that means that it's necessary and proper to make federal prisons, because, how else could you enforce these criminal laws and protect interstate commerce? And so once you have these federal prisons, you have to put them someplace. And they, by the virtue of the fact that the federal government is putting them someplace, they're creating new threats to the surrounding communities that didn't exist before there was a federal prison there. So that puts on the federal government an obligation to try to make sure that they're not jeopardizing the safety of those communities. And so therefore it becomes useful and convenient to safeguard the safety of the communities by doing things like having these mental health hearings before they release the prisoners into those communities. So they sort of are tying. It's like having this sexually dangerous predator hearing is a useful and convenient means of protecting surrounding communities from federal prisons, which are a useful and convenient means of dealing with people who violate federal felony laws, and having those federal felony laws is a useful and convenient means of protecting interstate commerce. So the court in Comstock actually does allow like a 3 or 4 step remove. That the measure that's being upheld is a useful and convenient means of doing something that's a useful and convenient means of doing something that's a useful and convenient means of regulating interstate commerce, right?
And I've always, I have a question about that, Ken. I've always thought about this. And again, this is me on the outside, but I've often wondered whether wherever you fell on the ideological spectrum, it seems to me that the court's understanding of, and because again, Comstock, you're right. I wasn't thinking about it in those terms. It's a necessary and proper case. I oftentimes think about it in terms of being a commerce power, but it's not. But they're connecting it back to a commerce power. It seems to me that you kind of have the Supreme Court pre and post its expansion of the Commerce Clause, and that during the era of FDR, you basically end up having the court eventually, for a variety of reasons, saying, well, interstate commerce is just about everything, right? I can't think of the name of the case. You're gonna say it as soon as I say some of the facts.
Wickard versus Filburn?
Yes, right. Where it's the turning point, right? Even if you're not engaging in intercase commerce, your inaction of not engaging in it changes interstate commerce, and therefore it's interstate commerce. It really feels like the court. It feels like Wickard was a kind of truly a terrible decision, and that downstream of that one, you get some weird things like Comstock because of the weirdness of the way they interpret the Commerce Clause. Did you guys get into that with Mike? And if not, I'm just curious what your take on that is, because again, I've always seen that as being like a terrible turning point.
Yeah. I think, Mike, we talked about Wickard, and we talked about the expansion of the commerce power into areas that may not appear to be interstate commerce. So
okay, we'll pause.
But yeah, we did talk about that. But I think that the necessary and proper clause, it's interesting because it hasn't been really it was never used as frequently as the commerce power was, but also the modern court has not really dialed it back the way they've dialed back the commerce power. So I wonder if we're going to see more examples of it. And one other necessary and proper case I've mentioned just for a second before we move on is so the case of Gonzalez versus Raich about marijuana is mainly a commerce clause case, but there's a Scalia concurrence which is only about the necessary and proper clause. And so it's an interesting way to think about it, where so you have this Federal Controlled Substances Act makes it a crime to have marijuana everywhere. We talked about that earlier in today's show, even. And so some states, initially started allowing medicinal marijuana. Later, they've expanded to recreational marijuana. But early on in that process, when California legalized medicinal marijuana, Angel Raich was a woman who had terminal cancer. She couldn't even get out of bed. She had a marijuana patch in her own backyard, and she had friends who would come over and harvest it for her, and she would smoke the marijuana that was being grown in her own backyard. And this was legal under California law. But somehow she got in trouble with the feds, and she got arrested and convicted of violations of the Controlled Substances Act. And in her case, which she took to the Supreme Court, she argued that Congress does not have any power to regulate home production and home consumption of marijuana. And her main argument was that that's not interstate commerce because nothing crosses any state lines and no money changes hands. And the majority of the court rejected that argument. So the majority of the court said, well, Congress can regulate marijuana under its interstate commerce power because marijuana is a commodity that does get sold in interstate commerce. Now, Scalia, who writes a concurrence, which is, I think, relevant to the things that we're talking about, Scalia says that he agrees with with Angel Raich that home growing and home consuming marijuana can't possibly be interstate commerce because the marijuana doesn't cross any state lines and doesn't change hands, so therefore can't be interstate commerce. But Scalia says even though there's no interstate commerce, and this is activity that Congress could not regulate under the commerce power, Scalia says Congress nonetheless can regulate it under the necessary and proper clause, and that's why he votes with the majority, and he writes a concurrence, not a dissent. And his thought is that since Congress clearly can prohibit interstate commercial sales in marijuana under the commerce power, that Congress could do that, that Congress should be allowed to use useful and convenient means to make sure that its prohibition of interstate sales of marijuana is effective. And that if people in a big state like California had the right to grow marijuana in their backyards and keep it and consume it, maybe some people like Angel Rach would just do that in an honest, legitimate way, but other people would just, grow it and keep it and maybe consume some of it, but save some of it until there's no policeman around and then sell it. And so Scalia says there's really no way that you could prevent a lot of marijuana from being grown and being shipped in interstate commerce unless the police are actually allowed to go around and see who's got marijuana. And so he argues that it's a useful and convenient means of preventing marijuana from falling into interstate sales, which Congress can do to make sure that people are not producing and possessing quantities of marijuana. So I think that's the way even a modern conservative justice would say that the Marshall's test from McCulloch could still apply to some circumstances.
Well, Ken, I agree. And I think what we're going to need to do, though, is say that I think we've handled the implied powers in this episode. Then when we come back, we're going to need to start taking on the enumerated powers, beginning after commerce, which is what you all had done a couple of weeks ago, and getting into things like naturalization, money, counterfeiting, things like that. And so we'll continue through the enumerated powers, if that sounds good. So following our normal thing, we got through one small portion of the Constitution.
Yeah, we can keep milking this Constitution for a long time.
I get, after that, I don't know what we do. Well, in 2027, we'll figure out that then. And, but if you're listening to this show, if you're hearing me and Ken giggle, what that means is you're a supporter of the show. So I want to say thank you so absolutely much. I hope that going through the Constitution has been and continues to be fun. I don't know about you, Ken, but I know some of my students would not necessarily always agree, especially when they're on call. If you're a supporter, you don't have to be on call. We're never going to look at you and say, give us the facts of the case. But if you have enjoyed this, if you'd like to take a look, it might be that you want to up your support level. Maybe you want to take a look at what some of the other possibilities and support things. I'll just remind you that you can do that very quickly at politicsguys.com/support. And of course, since you're a supporter, we want to hear from you. So please be reaching out on Discord and or email us at mail@politicsguys.com. Otherwise, I want to thank the executive producers of the Politics Guys, which are Bruce Johnson, Wilma Marino, Andra Masker, Daniel Toe, Ryan Beasley, and Don Oglesby. We'll be back with a new episode this weekend. We'll see you then.
This podcast is part of the Democracy Group,